Federal enumerations, these are individuals that by federal law, and again, state law can be more restrictive. The point I want to make here, and a lot of these we've discussed, these listed disqualifications. These come right out of the U.S. Code. They're very clearly specified in the 4473 form so that an individual doesn't have to go to the U.S. Code and buying a firearm and research it. These questions are called out on the 4473 form with some pretty good guidance by ATF. Nevertheless, there are problems that routinely come about with classes of prohibited possessors, and I want to give you one really important example. If you look at the ATF list, which is reflected in Chapter 44, it's reflected on this slide, and this will track the questions on the 4473 form, you're going to realize very quickly that there are a lot of ambiguities here that you wouldn't ordinarily think of as being ambiguities, like, what's a crime punishable by imprisonment of a year or more? Well, under some state law, a misdemeanor has a 2-year sentence. ATF's interpretational guidance still allows the individual to answer they've not been convicted of a crime, or qualify they've not been convicted of a crime, that they could go to prison for more than 2 years. That question is aimed at, do you have a felony, with one exception, that's domestic violence, and we'll get there here in a second. But these duties run to both the transferor and the transferee, meaning that if an individual, not even completing a 4473 form, an individual is liquidating a collection and sells a firearm to someone that he knows falls in these disqualifiers, both of them are committing federal felonies and probably a comparable state felony. So the duties run both ways. It's not one way just to the buyer. I'm going to run down this list and just hit a highlight of each of these bullet points to get you thinking about how these simple disqualifiers can be problematic. Indictment we've talked about. An indictment means you're under charge at the state or federal level for a felony, not a misdemeanor unless it's a misdemeanor crime of domestic violence. Unlawful fugitive from justice. I think that speaks for itself. If someone has a question on that, I'm happy to field it. Unlawful user or addicted to any controlled substance. I think with prescription drug regulations that have been handed down in a lot of states by the state medical associations, there's a real awareness that there are people that are addicted to prescription drugs. How that's going to play itself out in the federal arena or the state arena as it relates to this disqualifier, I don't know, but it certainly runs to illicit drugs as well as prescription drugs. Adjudicated as mentally defective or committed to any mental institution. Because of the focus, I think we all recognize certain mentally ill people shouldn't have firearms. Because of the focus that's come about by virtue of looking at this root cause, ATF has promulgated an awful lot of CFR sites, or proposing to adopt CFR sites to refine what this disqualifier means from the Gun Control Act of '68. They may well be substantive in nature and ultimately subject to challenge, but this is an area that if you're practicing with an issue that involves this, I would strongly recommend you go look at the case law in the different circuits, the cases in your own jurisdiction, ATF guidance, and certainly look at the CFR sites because they dramatically elucidate at a minimum what these categories mean. Illegal alien in the United States, there's a lot to deal with a foreign national purchasing a firearm. It is possible. I again direct you to relatively clear ATF guidance on that. Renounced citizenship, I've not addressed that particular issue. I think all the others I have. The one I want to look at is subject to a restraining order. Once someone asks for a protective order in a civil context, the states have all adopted these civil protective order registries for domestic relationships. That can be granted ex parte, but once there's a hearing, a judge can actually Brady disqualify someone, meaning they can't purchase or possess firearms as long as that protective order stays in place. So if they have a collection, you need to be able to have a plan. Where's this collection going to go? The police property room? Because they're no longer able to lawfully possess it. If they're a police officer, are they going to be able to work? These protective orders can actually be issued without Brady disqualifying someone under a technical reading of the statutes. So once they're heard, if they are a police officer, there may well be some ability for a court to not Brady disqualify them once they're heard. I'm not sure practically with these nationwide databases if that would work itself out to not be enforced as Brady disqualified, but theoretically it can be addressed in such a way the person's not Brady disqualified. So look at that particular issue if it is applicable to your client. Been convicted of any misdemeanor crime of domestic violence. I'm not going to speak to that yet because one of the reasons I changed the program outline is the case argued last week before the U.S. Supreme Court that is one step away, particularly with the death of Justice Scalia. It's one step away of addressing whether the right to keep and bear arms is an individual right again. It was only decided it was in 2008 under the Second Amendment, as at least as it related to D.C. It wasn't until McDonald in 2010 that the right was applied to individuals through the Due Process Clause of the 14th Amendment. So the domestic violence disqualification is being challenged in a case that I believe is called Vizone, and it was argued in front of the U.S. Supreme Court last week, and Scalia authored the Heller decision in 2008, which said D.C.'s gun ban is unconstitutional on handguns. How this may change with this decision, or does it signal a shift in the U.S. Supreme Court in what the Second Amendment means, I don't know. But it's probably, other than the Heller case and the McDonald case, the most significant legal precedent for gun rights, either as an individual right or a collective right that's come about as long as I've been in practice. So that's the reason I switched from search and seizure and stuck this in, because I think search and seizure is a relatively developed body of law. Certainly if you have those questions, whether it's suppression or some other type of illegal search and seizure, I prevailed on those cases with serious violent felons in possession. I'm happy to take email questions or questions here today and flesh that out, but this is real time and what you're supposed to get by virtue of this seminar, and my law's focus is what's really going on in the world today, and that's what I'm addressing as it relates to United States gun law. Again, we've talked about state restrictions can be more restrictive. The last point I'm going to throw out before I switch slides is something that will be very counterintuitive for most lawyers, and this involves several cases between state and federal government. There's a famous Wyoming case that comes to mind, and the name escapes me, but essentially Wyoming advised the federal government that their position on their domestic violence disqualifier was more restrictive than what Wyoming intended it to be, and ultimately the federal government prevailed in federal court, and the standard of review applied by the court was a very low standard. So this reflects some of the state sovereignty issues we talked about, but in actual, the ATF and the United States government in litigation in federal court, the state can lose its own interpretation of what a statute means under state law insofar as a federal disqualification is applied. There are some more questions about this topic, and to the extent we have time, I would like to address those, because this is really the cutting edge of gun law, both in terms of what the Second Amendment might mean, and is there going to be a departure from the Second Amendment, and or that this is the one area in the U.S. that a misdemeanor conviction can disqualify someone from what, as it stands today, is a constitutional and fundamental right.